Welcome to Mayor Brown's International Arbitration Across the Pond podcast. Each episode is designed to provide insight on legal issues and other matters affecting international arbitration in the UK, US and around the world. The podcast is presented by two of Mayor Brown's international arbitration partners, Kwadwo from the firm's London office and Charles Harris from the firm's Chicago office. You can subscribe to this podcast on all major podcasting platforms, as well as Mayor Brown's YouTube channel. We hope you enjoy the podcast.
So, Chucky, it's great to be back on the podcast, and I'd like to say welcome back to all of our listeners. We've had a bit of a break since the end of our last series, and I'm keen that our return should be marked in style, and I certainly think we have a subject that does it justice this time around. Over many episodes that we've done, we've been back and forth across the pond, we've been around the globe, but this time I think we get the chance to go one step further with our first venture into space. Chucky, you excited?
Yes, I am. I like that intro. And of course, as usual, last night I was thinking about the title, right? This is something we do, just telling my guests who we'll introduce shortly. And I had a long day yesterday, quite honestly. So I decided that I was going to get a little help from our generative AI tool that we use in the firm. And so the query was, give me a catchy title for a podcast on space law. And this is what I got: Galactic Justice, Navigating the Frontiers of Space Law. And I was
Wow.
yeah. And I just had to type. I didn't have to really think about it. So I like that. I just wanted to get your thoughts on that.
Well, yeah, that's certainly imaginative, Chucky. I know you come up with a few imaginative titles in the past, and it seems like this time AI is outdoing you. But let's get our guests on and let's see what their thoughts are. So we have two fascinating guests joining us today. One, Rachael, is a Mayor Brown colleague and indeed is a veteran of this podcast. Remember, Rachael, you shared your thoughts and views on treaty arbitration with us, which was fascinating. But our other guest, Laura, joins us for the very first time. Both guests are experts in space law. They both have unique and unparalleled perspectives on aspects of arbitration as it relates to space and the specific topics and issues that it raises. So without further ado, I'd like to invite each of you, Rachael and Laura, to say a few words of introduction, a little bit on your background, and say hello to our guests. Thank you.
All right, I'll jump in first. So yeah, I'm a veteran of the podcast, and nice to be back. Thank you for having me. As Kwadwo mentioned, I'm a partner in the IA International Arbitration Practice based in London, although obviously work internationally. I do commercial arbitration and investment treaty arbitration, but also for the purpose of this podcast, well, and in general, I head up the firm's space and satellite group along with another colleague, Paul Whitfield-Jones. And we've been doing that in an official capacity for about the last 3 years. And Laura, who I have known for many years, I will let introduce herself.
Yes, thank you very much. And thank you for having me. It's an honor to be invited to this podcast. So I used to be a counsel at Holland and Knight in the international arbitration and satellite teams until last summer. And I am currently finishing my PhD on investment protection in the space sector at the University of Cologne. And I'm doing this full time at the moment. So I think I can contribute some thoughts on arbitration and space.
Thank you, Laura. Thank you, Rachael. We're really looking forward to hearing from the two of you. So kicking it over to you, Chucky, any initial questions for our guests?
So, Laura, I know you didn't really give us any detail about the Space Arbitration Association and what you're doing with that. And, that sounds really interesting to me. So can you give us a little more detail about the association and kind of what the goals and the purposes are?
Yes, of course. So actually, when I was working at Holland and Knight in 2018, I started working on a big satellite case, and that drew me to international space law. I actually had never taken a class on it before, so it was quite new to me, but I had a background in public international law, so I found it very interesting. And then I started reading more about it, and I noticed that arbitration is a recurring theme in international space law, but mostly addressed by space lawyers who don't have often practical experience in arbitration. So I founded the association because I thought it would be interesting to have a forum where I could organize discussions between space lawyers and arbitration practitioners to kind of share different views and have like an ongoing debate on how to improve the dispute settlement mechanisms that are available to the space industry. So the association has different parts. So we have a series of webinars that can be accessed on the website. Since 2022, we've been doing more in-person events, so they're not accessible, but they do exist. And we also have a blog. So if anyone is interested in contributing, they can contact me. And we have a database of articles that have been written on dispute settlement and in the space sector, and several of Rachel's articles are on there, for example.
Why don't you drop your URL for us?
Yeah, I have to look for it, but yes.
No, I mean vocally for our listeners.
Well, if you Google Space Arbitration Association, you will find it.
Okay.
Fantastic. So, Rachel, you mentioned in your introduction, and obviously Chucky and I are well familiar with Mayer Brown's Space and Satellite Group, but can you share some details about that for our listeners?
Sure. Well, taking a step back in terms of how I kind of fell into this sector, which then led to the formation of the Space and Satellite Group. I, in a similar way to Laura, was an arbitration practitioner in a big law firm, and about 15 years ago, a launch contract dispute kind of fell onto my desk. And that was obviously a commercial arbitration under a domestic law governed contract. But because of my background in public international law and in investment arbitration, it kind of triggered this sort of interest in international space law. And that from that stage, I kind of started writing and podcasting and publishing, etc., on international space law. And in the context of doing that over the course of the last few years, I came across other people in the firm, not just in London, but across our international network of offices, who also had expertise in different areas of space law, domestic or international, and in different practices. So, you know, I met people who had done satellite financings, or corporate lawyers who had done kind of in-orbit sales of satellites, or former FCC former FCC colleagues who are now in our Washington office. And it just seemed to make sense to draw all that expertise together into a kind of an official practice group. And the colleague that I mentioned before, Paul Whitfield-Jones, he works in export control, and he was also of a similar mindset. So we kind of got together and we drew people around the firm, from different offices, different practices, but with that kind of space and satellite expertise in common, to kind of offer clients in the sector a kind of a one-stop shop, because obviously clients in the sector, they don't just, hopefully they don't need dispute resolution advice, but if they do, they can come to me. If they need export control advice, they can go to Paul. If they need other advice, they can just come to our group, and we can offer them everything we hope that they would need, with a real deep understanding of the sector and the different ways in which it works. So that's been formed now for about the last 3 years, and is going from strength to strength.
Thank you so much, Rachel. That's fascinating and really interesting to see how that's grown, and to hear from both of you how you came into this sector, which is incredibly exciting and sounds like it's growing rapidly. We switch to some of the context around the disputes themselves. Are either of you able to share some views, just to educate Chucky, myself, our listeners? what are the common or typical types of disputes you encounter in relation to space, or indeed in space itself?
Okay, I'll jump in. So, as your listeners may or may not realize, space, I mean, I don't even kind of call it an industry anymore because it's so many different industries within this sector. So you have, just like other industries, kind of upstream, midstream, and downstream. So upstream, you have kind of the satellite manufacturing agreements and contracts, the launch contracts. Then midstream, you have the what's going on when a satellite's in orbit, and then downstream you have the service provision of the services that are being derived from that satellite in orbit. And because there are contracts existing at each stage, disputes can also arise at each stage. Often they're governed by a contract which is subject to a domestic law. Often it's English law, often it's American law or New York law or so forth. But a lot of the disputes that I see are disputes arising from those kinds of contracts, almost all of which, in my personal experience, have arbitration clauses in them, given the international cross-border nature of the arrangement in question. We'll come on to perhaps other potential future disputes in due course, but those are the kinds of disputes that I'm working on kind of day to day.
So what I'm getting there is that arbitration is incredibly important.
Yeah, if I may add to that, I think we also see disputes, for example, with respect to the use of the frequencies and the orbital resources, which are maybe more specific to the space industry, because as Rachel mentioned, most of the disputes are contractual disputes that obviously require an understanding of the space industry, but are not typically based on space law. But then there are some disputes that really relate to the orbital resources that are being used, that are unique to the space industry. And then I think we will talk later on a bit about investment disputes, which also arise in the space industry.
Really interesting. So looking at questions then around jurisdiction, and forgive me if this is a simplistic question, but how is jurisdiction determined in relation to space law? Presumably there's no national sovereignty in space.
But it depends. If you're talking about a contract dispute, the jurisdiction usually is determined in the contract. No, if it's an arbitration clause, you would determine the seat of the arbitration in the contract. Then, if it's a dispute that really deals with, for example, a collision in space, I think it's more questionable which court would be competent to deal with that. I don't know if Rachel has any thoughts on that.
Yeah, I totally agree. It depends on the nature of the dispute, and what we see at the moment are generally disputes arising from some kind of legal framework which is rooted in a domestic jurisdiction. So although the activity in question and the dispute in question has as its subject matter outer space, actually it's set within a framework rooted in domestic law. The disputes that Laura alluded to, like the collision of a satellite, that obviously wouldn't be rooted in a contract or domestic law, and so then you do have to turn to international space law, and that's where more challenges arise, because the current international framework is old. That doesn't mean it's not functioning, but and it has functioned well, but it doesn't perhaps cater for the modern space age, given that it wasn't created in the modern space age. It was created in the middle of the Cold War, when no one could get to space apart from wealthy states. So it's more the challenges being posed by current technologies and developments are kind of slightly out of sync with the international legal framework governing them.
And for example, even if you wanted to bring a tort claim, for example, in a national court based on harm you suffered in outer space, be it a collision or even like collision avoidance maneuvers that can cause economic damage to operators, the question would be, to which court would you go? Because often under private international law, the jurisdiction of the court that is competent depends on the place where the harm occurred. So if the damage was suffered in outer space, then which court would be competent? No? So that's one of the issues I think that we might see in the future.
So are those issues arising now? Are there any court cases that either you, Laura, or Rachel can speak to, where there has been that tort claim or there hasn't been that collision, and there's no law that's necessarily set forth in a contract? Like, what are courts doing with that?
I think there's a further distinguishing factor to be made between whether the dispute is between states in space or between a private entity and a state in space. If it's between states, probably the most famous example was from the 1970s when a Canadian and Russian satellites collided. And in that situation, there was in the Outer Space Treaty, which is kind of the founding treaty, and the Liability Convention, which is kind of a bolt-on to that, there's a kind of a claims commission is foreseen for disputes between states, sort of similar to arbitration. And I can, talk about that in more detail. But what ultimately ended up happening is that there was a settlement because diplomatic channels were invoked, and I think all the parties involved realized that perhaps the most beneficial outcome for all the sides was to settle. So we haven't actually seen, as far as I'm aware, a state-to-state dispute being officially progressed through kind of a court proceeding before the ICJ or elsewhere. In terms of a private entity, either against another private entity under international space law, or a private entity against a state under international space law, I think that is yet to come. There have been close shaves. So recently we saw, I think, a Starlink satellite fly very close to the Chinese space station, and that kind of, which required some maneuvering, and a complaint was launched before the United Nations by the Chinese. But actually nothing happened, no damage happened. However, there will be a point, probably, unfortunately, within the next 5 years that I predict, where the anti-avoidance maneuver isn't successful and there is a collision, and then that will give rise to those sorts of claims. And just as a last point, the Outer Space Treaty actually makes host states liable for their national activities in outer space. So a private entity in space would only ever have a claim probably against another state rather than against another private entity, because it would be the state that would be responsible for the offending entity's actions.
Yeah, and actually maybe for those listeners who are not that familiar with the space industry, it's maybe interesting to mention that there are public and private tracking services. So most satellites and more even pieces of space junk are being tracked. And so there are warnings going out to the different operators when a collision might happen, so then they can maneuver the satellites to avoid that collision. But what's also interesting is that there are no traffic rules. So you get a warning you might collide, but there are no official international rules that would tell you what to do in that situation. So that creates an additional kind of layer of risk. And I've recently heard from an operator who said that he's sometimes getting different interpretations of whether or not a collision will or will not happen. So apparently, like, all of these systems are also not always coordinated. So we could maybe even imagine that we could see disputes arising out of the tracking services that are being provided. So yes, there haven't been any, as far as we know, there haven't been any tort or international claims yet with regard to collisions. But because of the situation that Rachel described, it's likely that this might change in the near future.
And another thing to add on to that is that because of this increased risk, we've seen the rise in space insurance. So insurance is actually a precondition for most launches imposed by the domestic legislation. So space insurance in and of itself isn't new, but there are all these new kind of insurance packages being offered to operators in light of the rise of kind of low Earth orbit constellations and increasing space junk. So that could be another fertile ground for disputes.
So I think across everything I've been listening to so far, the impression I'm getting is a space which is becoming increasingly complex, increasing numbers of players and operators, investors, and increasing volume of literal physical objects, be they satellites, space junk, and so on. Presumably, all of this is driving an increase in risk. What are the key risks that you see at the moment? I know you've illustrated some of them around collisions and so on, but are there others?
Well, I would say one of the main risks derives from the fact that the industry is highly regulated. So there are different states that regulate different aspects of sometimes activities of the same space object. So obviously all the links that exist with the different states to some extent represent like a bit political or regulatory risk, especially now with the current geopolitical climate and space being considered more and more as critical infrastructure and military assets. For example, maybe as a side note, most space technology is dual use. So even if it's commercial technology, it can often be used for military purposes. So that's why it's often maybe more regulated than other sectors. And so there's a lot of risk for investors who might face adverse interferences by their governments due to that strategic importance of the space sector. For example, with export control regulations, you could imagine that you might no longer be able to sell or buy certain technology because it's suddenly considered to fall under those restrictions.
Yeah, and following on from that, it's not just the amount of regulation, but kind of on the flip side, there's also a lack of regulation in many respects and a lack of legal certainty. So we mentioned earlier the Outer Space Treaty, and that was a deliberately kind of broad treaty enshrining these kind of wide-reaching principles, and it's worked really well so far for the last 70 years or however many. And that's great, but in terms of kind of because the new technologies and the new developments were not foreseen at that stage, there are, I suppose, gaps in the current legal framework and kind of the current space age, if you want to put it like that, that it doesn't say anything about. So I mean, for example, space resource utilization. There are no ownership rights granted in current international space law over kind of property in space. I mean, different parties have interpreted what the legal provisions that do exist in different ways, but the point is that there are different interpretations, and so there's a lack of legal certainty over many aspects. That's just one aspect. That there are others. Liability is another one. But I guess the lack of legal certainty for players who aren't lawyers, they're engineers, they're technicians, they're investors, they're financiers, and not knowing. I guess you can take out insurance, but you can just take out insurance to the maximum, I suppose. But really what you want is kind of legal certainty, what your rights are, what your obligations are, what your potential liabilities are. And that doesn't really exist. And it's kind of being created as the industry progresses, which, isn't the way that perhaps you'd ideally want it to be.
Yeah, maybe one example of the legal uncertainty that there is that nobody really knows where space ends and begins. So states have sovereignty over the airspace and not over outer space, because outer space is outside of the territory of any state, but nobody really knows where the border is. So for example, if you have a suborbital flight that might be most of the time within some countries' airspace and only very quickly in outer space, it becomes like difficult to know which rules apply and how they apply to different objects, which obviously is a problem for liability and insurance, for example.
So, one of the things that's interesting to me in hearing both of you talk is that I mean, a lot of this is uncertain. A lot of what we're going to see from the dispute standpoint is left to be seen. I mean, how do you predict that some of these issues, some of these gaps that we talked about are going to be addressed once these disputes actually do arise? Some of the things we're talking about is as far as tort claims and, you know, collisions and that type of thing. What's the prediction on how the law is going to deal with these things?
That is a really hard question to answer. I wish I had a crystal ball. I mean, so you just read the papers from, for example, from the legal subcommittee of the UN's Committee on the Peaceful Uses of Outer Space. It's a COPUOS, it's called in short term in the anagram. But it's essentially the UN's kind of legal subcommittee, like looking at lots of these issues, and they've been trying for years to kind of update international space law to create perhaps new convention or update the Outer Space Treaty, and it's just it seems impossible given the current geopolitical context and just the different levels of spacefaring activity of different nations. And so, but despite that, like, technology is not just going to stop. We are all, let's be clear, going to benefit from all these amazing developments which are taking place. So when someone kind of asks for what's the answer, I don't know. To be honest, it does seem that the industry is leading now the kind of the regulation. So, for example, private companies are coming together and, for example, making pledges about, you know, sustainable missions and zero impact in terms of sustainability, and always having an end of life plan for satellites. And so whether a similar coming together of minds will be created for kind of the resolution of disputes, I don't know. I would think that that would be in the interests of everybody, obviously, because I'm a biased arbitration lawyer. But I mean, we've seen the creation of space courts and arbitration, space-specific arbitration rules, but as far as we know, there hasn't been any uptake. And as we also know, arbitration is a creature of consent. So unless both sides consent, then who knows where it could end up? It could be messy.
But thank you, Rachel. But I guess, Laura, the activities of organisations like the Space Arbitration Association that you founded are going to be pretty key in driving the conversations and pulling together ideas and innovations and so on, which are going to be resolving these issues.
Thank you for believing in the association. I don't think it has such an important role to play, but it's interesting to see that since the 70s, when it became more difficult to agree on treaties for space activities, for example, there have been several efforts of creating soft law, and that has been to some extent quite successful. For example, there have been space debris mitigation guidelines that were published in 2007, I think, by the UN committee. Based on earlier guidelines, but anyway, the UN guidelines are from 2007, and they have been widely used and implemented into national law. So they were not binding on the international level, but they have become binding on quite a lot of private parties and have since been updated in national laws. So it's interesting to see that even though there may be no international rules, there is some movement within the industry and on the domestic level of trying to agree on binding rules.
Okay, so one of the questions I had, Rachel had briefly mentioned earlier, you know, kind of how private industry is helping in resolving some of these disputes, or at least setting up a framework to help resolve some of these disputes when they come up. And I just wanted to understand more generally how the entrance of private companies into space has affected disputes and just affected the industry in general.
So the entrance of the private market into space has revolutionized the entire industry. I mean, we now have a kind of total U-turn on the situation in the 1960s, where it was the states driving their space programs or state organizations. Now they're kind of depending on the private sector. We've seen you know, the Crew Dragon is now taking loads up to the International Space Station. You know, other NASA's partnering with private entities to drive its, its programs. So it's totally changed the entry of private companies in space. Launch costs are coming down, reusable rockets are now being used. I mean, it's revolutionized everything.
Yeah, maybe to add on that, there has been more and more private investment, and that has developed, for example, different launch rockets, which has brought the cost down because the cost of launching has been reduced. New business models have been developed, and that has attracted new investment. So kind of, I don't know, Rachel, if you agree, but I would say that kind of through the privatization, there has been an ongoing commercialization of space also going on. And there are more and more activities. And for example, one example is the International Space Station, which is a government-led initiative by different states, and that will be deorbited in the coming years, and the replacement will be commercial. There are, I think, now 4 main leading projects for commercial space stations that will allow, to some extent, manufacturing in space tourism. So everything is becoming more commercial. But one still has to say that a lot of the things going on, to some extent at least, rely on public funding. And that's one of the reasons why I think there have been more projects in the United States than in Europe, because there has been more venture capital available. And I think there's an idea now that because Europe is kind of now trying to invest more in the defense sector, that the space companies in Europe will to some extent benefit from those big contracts that then maybe lead to new ideas on new things that were not otherwise possible.
One thing to note, despite the kind of the avalanche of private entrants into the space sector, is that under international space law, it is the states that themselves, either the state, the nationality state, let's say, or the launching state, i.e. the state where the launch happens from, those states remain responsible for the national activities of the private entities. So the private entities themselves aren't per se under specific obligations in international space law. So it's up to the host states to regulate them and ensure that they're regulated in order to avoid their own liability at the end of the day. And perhaps one of the reasons that the United States has spawned so many successful private initiatives is because perhaps the United States government has been prepared to support its companies in that way.
So Rachel, listening to what you and Laura have just been setting out, and hearing about the increasing activity of private entities, but also the degree to which that is in tandem with the activities of states, the support and funding and so on. That brings to mind the question of investment law and how that might play a part. And obviously, I know you're very experienced in relation to investment disputes. Is that something that you've applied to space, or you're seeing being applied to issues in relation to space?
So there are 6 currently known, it might have updated since the last checked, investment treaty disputes that relate to the space sector, or that have related to the space sector, one of which Laura worked on. So yes, it is in principle possible if you can establish, as with any international investment arbitration, a qualifying investor, and the investment in question has been made in the territory of the other contracting states, and this is the tricky bit, and that investment has been harmed by the host state. So I guess there's in the 6 that public investment treaty cases that are known about, those criteria have been fulfilled, and there was an investment in the territory of the other host state. That can be because it was, for example, the allocation of spectrum, or because there was an object on the register of objects launched. But there may be hurdles in meeting those criteria depending on the investments in question and the dispute in question, in relation to kind of the disputes that may come. I know this is a topic that Laura's been looking at very closely. I don't know if you have any comments, Laura.
Yeah, I mean, I think if you really look at the investments that are being made in the space sector, there are very few where you would not have a very clear link with a host state. Because, for example, under many international investment treaties, or most international investment treaties, for example, licenses qualify as a protected investment. And all space activities are licensed. So I think through the license, you would have a clear connection with the licensing state. So, for example, even if you have a license to mine an asteroid in deep space, you could probably say that even though the activity is taking place in outer space and therefore outside of the territory of the host state, if you pay for your license, for example, in a state, and that's, for example, if you're mining and you bring back whatever you're mining, or the state to some extent benefits from what you have mined, then you could probably argue that there is a clear connection with the state that would allow you to determine that state as the host state. But this is very theoretical at the moment. I mean, to some extent, this is the topic of my PhD thesis, which will be hopefully published at some point, but we don't know yet because there haven't been any cases addressing these issues in practice.
Well,
I
thank
think
you,
it'll
Laura.
be a really interesting area when they come to see how tribunals treat these cases.
Maybe
And it'll be
Rachel
really
will
exciting to
the
read
first
your
arbitrator
thesis,
to-
Laura.
Right. Thank you.
Moving on to another subject here, Rachel and Laura. What excites me in relation to space is all the possibilities and the exciting developments, some of which you've already talked about, but you can see things are moving forward so quickly and are continuing to develop. What do you see in the near to medium term as new activities taking place in space or in relation to space activities, space exploration? And how do you see either disputes or legal issues arising in relation to them?
Why don't I jump in first? Okay, I think the next thing on the horizon for orbital activity, let's say, is in orbit servicing. So that's basically companies going up into orbit and staying in orbit, which then use or have the ability to use resources that they can kind of harvest in space, like water, so ice, for example, from the lunar South Pole, and they can break that down and create like rocket fuel, basically, or oxygen for astronauts, or water for human sustainability. So there are these petrol stations, if you like, that are going to be, or kind of service providers in orbit that missions can kind of hook up to and receive services from, and then kind of go off, and that will really reduce mission costs because they won't be having to come back to Earth to refuel or restock, and it will therefore prolong the life of missions and prolong and extend the potential scope of missions. So especially with having, the mission for Mars in mind, and etc. I think that will really revolutionize space operations in a similar way to reusable rockets did. Now that we've got those, it's all about kind of bringing down costs and using what we can kind of find in space and use it in space to then propel us even further forward. Laura, I think you had an idea as well.
No, but maybe just to talk about the legal issues that are arising out of that, is Rachel explained earlier that under international space law, there are no ownership rights for private parties or even for states over space resources. I mean, it's not explicitly regulated. And the Outer Space Treaty has been interpreted by some states to allow private ownership over space resources. Some states are kind of opposed to that idea, but more and more states are signing up to the possibility that you can authorize private parties to own space resources. But this is an interesting legal area to watch in the coming years to see how it will be decided in practice by courts. interesting.
Especially because there's a kind of whole spectrum of what constitutes a space resource. Like it could be anything from kind of solar power, which satellites use anyway because they've got their solar panels on their wings that they use to generate their electricity to fuel themselves. Then it could to kind of further down the scale, you have kind of the ice or the regolith that you can just kind of collect from the surface of the moon or an asteroid or a planet. And then even further down the scale would be the actual extraction and the space mining. And so it's at what point, maybe it's right from the outset that these questions will arise, or if not from the outset, at what point do we really need to start thinking about, or do companies really need to start worrying about legal certainty to what they do or don't own? And yeah, I think that will come into play. I think I read somewhere that lunar mining or lunar resource utilization will become commercially viable by the end of the 2030s. So it's not that far away. And asteroids by the end of the 2040s. So yeah, it's the legal frameworks or lack of legal frameworks around these activities, which will be interesting to watch.
It sounds super futuristic, but there are actually quite a few companies already working on these projects. So it's not that far away or unimaginable that we will see it in our lifetime. And I think relatedly, another activity that is already taking place, but that will expand in scope, is manufacturing in space. So there have been quite a few, research projects and attempts to do this. It hasn't been done on a bigger scale, but with the launching costs expected to go down even further, those business models will become more viable. And in microgravity, you can, for example, produce human organs, which will obviously revolutionize medical applications on Earth. So there are these kind of initiatives that are ongoing that are very interesting as well.
Kwadwo, it looks like you wanted to say one thing before we go to our closing thought.
Well, no, I was just going to say that's incredibly fascinating to hear that not only manufacturing might be taking place in space, but it might be possible to do that in relation to medical breakthroughs and vital organs for transplants and so on. Well, I was just interested in with regard to the R&D that goes into that and potentially intellectual property rights and so on. Are there wrinkles or difficulties where that's taking place in space and not on a terrestrial jurisdiction, as it were?
Well, Article 8 of the Outer Space Treaty says that basically just because you construct something or its component parts in space doesn't affect the ownership of that. So there is something in the Outer Space Treaty. Whether or not it's enough to cover what's going to happen is another question. But there is the kind of principle there that just because you're doing something in space doesn't necessarily alter the characteristics of its ownership. Question whether that extends to IP and everything else. Laura, what do you think?
Yeah, no, I agree. And there are also some domestic laws that explicitly regulate that their domestic IP law applies to outer space. Whether that will then be recognized internationally is another question, but at least there are those laws, for example, in the United States.
Yeah, and we're seeing an increasing number of countries passing increasingly kind of future-looking domestic space legislation as well. So although on the one hand that might lead to kind of slight fragmentation of kind of space law on Earth, it's at least creating some certainty for those that can take advantage of those benefits.
So you guys don't think the 9/10 of the law principle is going to apply when you're talking about resources and IP rights ultimately?
Again, I say it's hard to predict. I think I think this is going to be fertile grounds for disputes. I think that's the one thing that is certain. I think there's going to be lots of different interpretations, fueled by lots of different motivations. And yeah, I think the lack of anything cohesive and kind of clear on the legal front will inevitably lead to disputes, but hopefully that will then create some kind of precedent and practice that will then in turn, in time, create certainty.
So you're going to be busy.
Yeah. So look, I mean, Laura, and Rachel, this has been a great discussion, and I've certainly learned a lot. Just as closing thoughts from both of you, what steps can the international community take to better prepare for and manage future disputes, space disputes in particular?
Well, personally, I think that there are frameworks that are already there that would allow to litigate these kind of issues and come to conclusions that would be beneficial. Obviously, if it's private arbitration, it will be more difficult to derive any principles from that then can be replicated in other decisions. But I think so far the disputes that have arisen in the space industry have been resolved well, and I think we will see how the system will deal with what will come.
So I have in the past floated an idea of the creation of an ICSOD convention, so that an international centre for the settlement of outer space disputes, which would provide a forum where private entities could bring disputes with states and perhaps vice versa. But there needs to be some sort of mechanism where that centre could be kind of included in treaties and or contracts. But it would seem to me to make sense to at least put a dispute resolution framework in place, given all of these potential issues that may occur in the future. Even if we can't agree on changes to substantive law that everyone can, sign up to, at least surely we can put in place some forum whereby private entities have recourse against states. I agree with Laura. For commercial disputes, I think we're covered. We've got great arbitration institutions. For state-to-state disputes, we've got the ICJ, but there's nothing currently for private entities against states, other than perhaps tort claims in domestic jurisdictions. So that would be my advice.
And investment claims. So you'll see how some of the disputes can fit into that system. But yes, I agree. I mean, a new convention would be beneficial.
Thank you. Kwadwo, any closing thoughts from you?
Well, not really, other than to say thank you so much to each of you, Rachel, Laura. I've learned a hell of a lot, and it's just got a sense for what an exciting subject area all of this is. It's fast developing, it's complex, it's not only international, perhaps even intergalactic, to return to Chucky's title, but it's particularly interesting, and it's something that I think it's an area where I think arbitration and the skills that we have as arbitration lawyers really can be brought to bear in order to make for a more predictable and smoothly operating system and complex in an area where things are developing so quickly and there are so many exciting new developments emerging. So thank you very much to each of you. I really feel I've learned a lot.
Thank you.
Thank you so much for having us.
We hope you enjoyed this podcast. If you have any suggestions for topics or want to reach Kwadwo O'Grady or Charles Harris, you can find them at the Mayor Brown website, mayorbrown.com. Also, to learn more about other Mayor Brown audio programs, please visit mayorbrown.com/podcasts. Thank you for listening.